Okay, I won't be able to get the super chats, but thank you very much for all of these. Robert, let's get into this. Flynn, is he a free man or not yet? Because I said he was. I entitled my video "Free Man," and then I realized he's not yet free until Sullivan actually follows through on the mandamus that the Court of Appeals issued against him. So what's the time frame? What's the next step?
He stayed it pending the Court of Appeals possibly taking the case en banc, but he did not request an en banc review. So and no one else is either. So that means now what happens is the way the Court of Appeals work is that when a 3-judge panel issues a decision, the entire circuit, that's what they call it, en banc, can, if they decide, take up the case. Extremely rare that they do. Often only when there's a conflict with an existing decision. This case was not in conflict with any existing decision. So Sullivan simply left open the option of the en banc appeal being taken. Once that doesn't happen, then what they call the mandate from the Court of Appeals issues, then he has to dismiss. So, there's about a 99.9% chance Flynn will be a free man by July 4th.
By July 4th. So, and for anybody who doesn't know what happened, and we all know what happened with Flynn from the beginning. We did videos and we did discussions on the amicus brief that was filed before the Court of Appeal hearing. We talked about the Court of Appeal hearing where arguments were made. Court of Appeal just came down 2-1. Who was it? It was Bush and Trump judges against the Obama judge. The 2-1 said Rule 48A has to be, interpreted narrowly, strictly, only exceptionally to be applied. It was to prevent prosecutorial harassment. They said that basically what the judge had done here was effectively hired his own prosecutor to argue in opposition to charges that were being dropped by the very prosecutorial entity that presses charges. Basically, they came down on the side of exactly what was argued in the DOJ's motion and Flynn's. The Obama judge said the Obama judge said Sullivan hadn't decided anything. That there's no clear right to the remedy being sought. So mandamus is inappropriate. And there was another exercise there where he said it allowed for additional inquiry by the judge before granting the motion. So I don't know if anybody can hear a screaming kid, but they might be screaming and even more tired. Robert, I mean, obviously you read the decision. Who do you agree with? And what do you think of the dissent's opinion?
So, I mean, I think the decision ended up being exactly what we predicted on the show a couple of weeks ago. After there was the majority legal opinion out there was that the dissent was going to be the majority. I argued here that was not going to be the case, that Henderson, the Bush judge, would likely side with Judge Rao, the Trump appointee, because of the consequences of not wanting other judges to open this Pandora's box to becoming de facto prosecutors like the European system does. And so and that's exactly what happened. And the nature of it, the dissent, I can tell you that same dissenting judge with about 95% predictive accuracy that if this was a Obama or official that was on trial, would have issued the exact opposite opinion that they did. I have increasingly low respect for a lot of Obama judges. They're political. In a political case, I can predict what they're going to do based on the politics. And that same judge 2 years from now, if it's an Obama defendant, will reverse themselves with ease. I mean, it's very unfortunate to witness how overtly political they are. And I found the dissent unpersuasive because the problem was if Sullivan had simply failed to rule, had done nothing but failed to rule, then there was an argument that they should wait until he makes his ruling before asking for the writ. But that isn't what he did. He appointed a special prosecutor effectively to prosecute the case against both the government and General Flynn, and was green lighting discovery and additional prosecutions against him. So the nature of it was such that the point that the majority made was that this goes directly against the executive prerogative to protect the executive privilege about what decisions they make and what motivates their decisions. And that given that it made no sense whatsoever to move forward. Sullivan's great mistake here was appointing the amicus. And then the amicus made clear just how ostentatious and over the top he was going to be with his argument. So the Court of Appeals knew that this was going to be a circus sideshow, and there was no way they were going to let it happen. And so that's what convinced Henderson. she couldn't allow that. That if she had confidence that Sullivan would make the right decision and was just go through a few rigmarole and make a few political points at a hearing, Sullivan might have had his opportunity to get the writ denied. But he appointed an amicus, threatened contempt, which itself was bogus. It's another time Judge Sullivan can't interpret basic criminal statutes. What does that tell you about federal judges? They can't interpret a basic criminal statute, just like he couldn't interpret treason. And he's been on the bench a long time. So these were embarrassing rulings by Judge Sullivan, and the only remedy was he couldn't help himself. So the Court of Appeals had to help him by telling him what he needed to do, and it will happen.
And this was actually one of the things that I read the dissenting opinion. I might do a separate video on it just because, Robert, I mean, you've read judges before. There is clear animosity between the dissenting judge and the majority judge, like personal animosity.
No doubt about it, but in particular because Rao took apart the dissenting decision in their own. You'll usually see in a majority opinion some reference to the dissent, not here's the 8 reasons why you're wrong, and it was just piece by piece. It was just shredded it to where the dissent, had no real argument left that beyond a political one. And hey, maybe Sullivan will do the right thing, so let's wait. That ship had sailed. So and to argue what the dissenting judge was arguing was just not a very credible argument. But I've noted Obama judges take things personal. They're very political, and they've been taught to bend the law to fit whatever outcome they want. And they believe that they convince themselves that their argument is a legal argument when it's an overtly political argument. And everybody in the room but them knows that's what's happening. And it does trigger this degree of antagonism on the court, because it's hard to deal with these kind of overtly. We've never really had judges this overtly political since the 1930s, where we had a vestige of a whole bunch of old school economic conservative judges who were creating crazy constitutional interpretations to strike down things like child labor laws. And it took FDR saying, well, maybe I'll add nine Supreme Court justices for them to go, oh, okay. Now we get the message. So that's the last time we had judges this bad, in my view. We've had judges in the South between 1880 and 1950 that were a joke, that denied civil rights forever with every shenanigan known in the book. But this is pretty bad, and I think you see the intensity of it reflected in the difference between the dissent and the majority, and the majority's readiness to tear apart intellectually the dissent in their own opinion. I mean, almost half the opinion is tearing apart the dissent.
So for anybody who hasn't read the decision or hasn't seen my last video on it, I think it was easily, in substance, 50% of it. They went through Sullivan's arguments, then they went through, I think it was 7 or 8 points of addressing each argument raised by Wilkins. Sorry, who was the dissenting opinion again?
I believe that's the dissent.
Wilkins. Yes. And you read it before you read the dissenting opinion, so you already, if it's not going to influence your opinion, it will invariably. You get to Wilkins' opinion, and it's already been destroyed by the 5 preceding pages of the majority decision. But one thing that Wilkins said in particular that it just seems untenable was that this should be viewed only from the prejudice to Flynn and not to the prejudice of the system, the executive branch, and the separation of powers, because Wilkins says the government is not the one asking for this writ of mandamus, it's Flynn, and therefore the only prejudiced party we should be considering right now is Flynn and not the government, whereas the majority said no, because if this gets by and if this passes and we see judges authorized to do what Sullivan is attempting to do, you're basically empowering every judge to act as prosecutor in their own case, totally usurping the executive power, prosecutorial power. And I read the majority and I read Wilkins' argument. It was shallow and superficial. It's not a question of being biased. It's just a question of not addressing the inevitable, that it's not, the government doesn't have to make the writ for the petition for the writ for the petition for writ of mandamus. They clearly stand to suffer prejudice to the system itself if judges are authorized to do this.
Exactly. And they effectively joined it. So they were relying on, trying to rely upon a sort of procedural, technical out to say, well, technically it was initiated by General Flynn, so let's pretend he's the only party here, is effectively how I read the dissent. And that's just not credible. And maybe at one point that was my guess is what happened is Henderson would have normally written the opinion as the senior judge, and they both wrote their opinions, and then Henderson decided which one she was going to join. And so I think that's why what you're seeing is so strong. And Henderson and that's why the dissent was like, hey, you don't have to deal with the executive branch because technically they didn't initiate the writ, and it wasn't credible given what had happened in the briefing and oral argument.
Okay, and now actually Fozzie Bear says, can you talk about Sullivan ignoring the writ of mandamus by suspending the case instead of dismissing it?
He hasn't ignored it. The writ technically does not issue until the Court of Appeals has a chance to decide in a 14-day time frame whether or not to review the case en banc. So the mandamus becomes a mandate when that time period elapses. So until then, that's why he's suspended. That was not people interpreted that as him trying to do something that actually wasn't. That's what he's supposed to do, is just stay everything until that happens.
And the 14-day en banc, which means in bench in French, that is as of the date of the panel issuing their decision.
So exactly, it was they issue their decision, but it doesn't become a final decision of the Court of Appeals until the Court of Appeals time period to consider the case en banc. They're given 14 days to decide whether or not they want to take it en banc. Then if they do decide to take it en banc, then that's its own schedule. But typically speaking, they deny. I don't see them granting en banc review here.
Okay, and does the en banc review have to be specifically made by one of the parties, or is it sort of like a de facto automatic appeal that the bench would decide to review it not on petition from one of the parties?
You can request it, but I don't think anyone has. But the other thing that can happen en banc is a judge can. So it wouldn't surprise me if the dissenting judge has requested en banc review by the rest of the panel. But I'm pretty certain that Obama does not. There aren't a majority of Obama appointees on the D.C. circuit anymore. So I don't think they'll take that gamble, and consequently, I don't see them granting en banc.
It's amazing because the majority decision was meticulously drafted. I mean, I couldn't see how they would decide to do it, let alone then overturn the majority decision, given what the majority already said, which this would effectively allow judicial usurpation of executive power. I don't see how they could even entertain that idea. But it'll be interesting to see if it goes there. Let's see here. I'll just read this one. Do you think they'll get away with this? This is part of the Russian narrative where they used to use by MSM to basically ruin and taint the population against Trump for over 3 years. It's sinister. It's a matter of, I mean, I don't think some people would disagree with you. I think other people might. So you're saying that the Obama judges think they're making legal arguments. In reality, they're making regal arguments. Real Bambunga with the pun. And now we got Uncivil Law who says, you're saying legal would have been a fantastic Obama judge appointment.
That's your example of they do have a little higher IQ than illegal. Well, that's all I can say.
We're going to talk to I'm trying to maintain cordial relations with legal so that maybe he can explain his lawsuit to me in a live stream, because we'll get into it. It might only be a 5-minute discussion. So, okay, so 14 days by July 4th, we'll know if the full Court of Appeal is going to take it en banc. If they don't, then what? The next day Sullivan has to, or is it sort of like an automatic issue?
What happens is the mandate issues, and as soon as the mandate issues, then that's the writ ordering him to do so. He'll dismiss the next day. And
I mean, does he have to sign it? Does Sullivan have to sign the writ personally?
He signs the order of dismissal.
It's amazing. And now, I said it in the video. I'm curious to know what you think. Did they not remove him from the bench out of spite, out of shame, or to allow him to save face?
That's Henderson. Henderson has a personal relationship with him, was on the bench with him at the district court level. So that was the only argument really that the dissent really could have had, was to protect Sullivan's reputation. But ultimately, the procedural posture didn't allow that to happen. So that's Henderson saying, no, we'll let Sullivan fix this. I'm not going to smack him across the face for what took place. The order is sufficiently makes clear what the law is, but without embarrassing him personally. The opinion says a lot of things that would be embarrassing to most judges already.
And so it would have been more embarrassing to reassign the case than to force him to issue the writ.
Correct.
Okay. Because there's some people who are saying, they left him to rub his face in it. Others are saying they didn't reassign him because that would have been rubbing his face in it too much. So you could sort of read the same thing both ways. I thought part of me would, part of me thought maybe they were really rubbing his face in it by forcing his hand to issue the writ, whereas reassigning it, could have been explained away through other justifications. But
More than a few judges have had to reverse themselves by writ. Reassignment is very rare and considered very embarrassing, and it becomes an issue in future cases. So it's a sign of that you are so biased you can't be a judge. Getting the law wrong and having a writ is embarrassing, but not humiliating. Being reassigned is a sign that you're so biased you don't belong on the bench, basically. So that's they avoid that at all costs, and judges find that much more humiliating.
And so we're going to bring up Isaac Castillo, who says, what's your take on Judge Sullivan saying he's not required to rubber stamp DOJ's bid to dismiss Flynn's case, reported via Washington Post? One thing I have found shocking, I mean, I say shocking, disheartening, surprised but not shocked, I guess. The media reporting on this is madness. I mean, it's like there hasn't been a judgment. They just repeat the same thing, dismissed despite the fact that he pleaded guilty. The rubber stamping argument that they're still repeating. This was another superficial thing. Sorry. Go ahead, Robert.
Yeah, I was just going to say, and additionally, the New York Times has a hit piece out, I think today, in the Sunday New York Times, saying that this was all dealing with backdoor lobbying by Sidney Powell in the Justice Department, which is a bunch of nonsense. What Sidney Powell did is she made clear to Barr up front, this is a bad case. I'm going to expose it as a bad case. I'm going to give you the professional courtesy as the Attorney General of the United States to have an opportunity to fix it before it becomes a really bad case. I've done this multiple times. I've explained this to all political actors in a range of cases I have. It's like, this case will be embarrassing. You can either fix it now to limit the damage to the institution, or you can suffer the consequence. And in every single case where they have gone forward, where I've made that prediction to them beforehand, they have been embarrassed and humiliated. There was a prosecutor who figured out mid-trial that he was about to be humiliated. He did a sweetheart deal for my client, and now he sits on the federal court because of that, because he figured out, oh, Barnes was right. I got to get out of this thing. So so they're trying to make ordinary, everyday activity by professional lawyers look illicit and suspicious. It's ludicrous, the behavior. What has been exposed, and I don't think my friends on the left recognize this, is like all of them signing these letters objecting to Barr, dismissing, and all the rest. They're exposing just how politicized and partisan the prosecutorial branch has become over the last decade or so. And I've been complaining about it for a while, dealing with prosecutors who don't look at facts, don't look at evidence. There was a recent Billions episode, Showtime, great show if you want to understand the criminal process, how it really works, where these young interns come into the prosecutor and they're like, you've assigned us a project where we're supposed to, we know you just give us the man and tell us to find the crime. That seems unethical. And he demands they all leave because he goes, anybody that doesn't put loyalty first to me needs to go home now to Yale Law School in the show. That's the real mindset and mentality. A lot of these prosecutors, and they've politically corrupted justice in the United States, and they think they're championing high ethics when in fact they're exposing their complete lack of ethics, and they don't understand how much damage they're doing. The last bastion of people who believed in law enforcement were conservatives. The people on the left have long had doubts about it. African-American community has experienced enough bogus prosecutions to have doubts about it. People in lower income communities, the Latino community, already have personal experience that leads them to doubt it. The last group of true law enforcement supporters were conservative Republicans, and they now have been educating them how political and partisan and corrupted the process is. The FBI is going to have a record low level of approval in new surveys. Justice Department's going the same path. Now, as a defense attorney, I don't mind that. I like the public getting educated on the reality of the situation, but they don't realize how much they're damaging their own institutions and the credibility, because these institutions only have power to the degree people believe in them. Once you have 20-25% of juries who no longer believe in it, you no longer can secure convictions. You can no longer secure confidence in judicial rulings. So they should learn to realize they don't have the power of the purse. They don't have the power of the pen. They don't have the power of the sword. They need to step back and recognize that their whole power is based on the credibility of their institutions, and they've been wrecking it wholesale with the last several years, and particularly bad in these cases. And not only that, there's another reason why Barr got dumped this case is because more bad evidence came out. I mean, the most explosive evidence related to General Flynn they had been hiding all along only came out a day or two before the writ issued. And what it was is Peter Strzok's own internal notes that show this was an Obama-driven plan to get Flynn, and that Vice President Biden was neck deep in it. And so it shows Sally Yates, corrupt prosecutor, been dealing with her for more than 10 years. So anytime I get a chance to tell people Sally Yates is corrupt, I do. I might be having a beer with somebody and tell them, by the way, Sally Yates is corrupt. So she went after a good client, a good friend of mine from Atlanta, bogus prosecution, put him through hell for 10 years, did to General Flynn what she did to him for 10 years, what they did to General Flynn for 3 years, almost ruined his business that employed people, disproportionately working class people from different African-American and Latino backgrounds. Just incredible what tried to do. So this was a corrupt group of actors who's been exposed, but I think Barr needs to take follow-up action to prosecute some of these people in order to restore confidence and faith and the impartiality of our justice system.
And to the rubber stamp question, it was in the majority and the dissenting opinion where dissent said the judge is entitled to an inquiry. The majority said, yeah, this was not a 3-line motion. Please drop the charges. This was a highly meticulously detailed, I forget what it was, 40 some odd page motion detailing the new evidence, giving all the consideration that the judge would need to, if he wanted to have a hearing, listen to the motion. It was not a question of rubber stamping. It was just a question of not opening up a debate, a Pandora's box, chasing windmills, inviting a hostile amicus to come and reopen debate about other issues that had nothing to do with this, basically to explore the prosecution's decision-making process. There's a fine line between a rubber stamp and a full, I don't know what's the word I'm looking for, investigation.
Well, and the reality is, as long as there's not prosecutorial abuse taking place, the job of the judge is to rubber stamp the executive branch in this context. So the rubber stamp language never made much sense to me. That's the judge's job when the executive branch says there's not probable cause to move forward.
Yeah, Sullivan could have had a hearing on the motion as drafted, could have done whatever inquiry he thought necessary given the file, but instead decided to hire his own prosecutor to create his own file to counter the already complete file that was presented by the DOJ. It was not a question of rubber stamping, and any outlet repeating that rubber stamp didn't read the decision or didn't understand it. And Tailix001 says, from what is known now, released documents, this is speaking to what you just said about pressing charges against someone. Barr should hit the FBI up. What charges, if any, could be brought and against whom? With the known public information, surely some charges with the known info could be brought.
I mean, clearly against the prosecutors, they were hiding evidence. Clearly against Peter Strzok and others. Anybody that was sort of complicit in this process. And truth be told, now I don't think they're going to go there, but I do think this came from the top down. I think it came from Obama, based on Peter Strzok's notes, basically. And that was always clear with Susan Rice's bogus CYA email she wrote on the eve of Trump's inauguration. That was almost a telltale indicator that something deeply problematic had happened at that meeting in the Oval Office, and now all the evidence mounts towards that. The case was going to be closed. Even James Comey told Obama there was nothing wrong with Flynn's calls, and Obama said no. And it was Biden who said, hey, what about the Logan Act? And then Sally Yates went and acted on it. And then they set up the entrapment meeting. And then they did bogus charges. And then they hid the evidence of what took place. So there's a lot of people who could face consequences. I'm not overly confident that a lot of people will. I hope so, but because I do think Barr is serious about cleaning up at least the appearance of integrity in the Justice Department. But so far, there's been 0 prosecutions. 0. Mueller didn't take this long to act, that's for sure.
And will Flynn be able to get legal fees? I mean, we mentioned it earlier, but is it becoming increasingly possible or just still unlikely?
He should definitely sue that law firm. I've told his people that sue the Covington law firm. I'll be happy to assist.
But now there's two ways to get the fees back. One would be to sue his conflicted prior law firm. The other
suing the government's a waste of time. It's almost impossible.
Okay, and we got thanks for the vlogs. Shout out to mandamus. Now, I just forgot how I wanted to end this. The bit was the rubber stamping we were talking about. The corruption, that was it. Other headlines repeating the fact that he pleaded guilty. And again, any article repeating that he pleaded guilty without citing the newly disclosed evidence, which was withheld from him. I guess it'd be a good time. Explain to everybody what the Brady requirements are, the Brady disclosures. I think everybody knows, but just in case.
Sure. So it comes from the Brady case, and it's all about the due process clause of the U.S. Constitution, which is that you are under the due process clause. The prosecutor has a duty to provide any information to you that could be helpful in preparing your defense. And that's not just for trial. Now, some courts have tried to limit it to trial, but that was not the intention of the Supreme Court's principles in it. The intention was anything. That means, could it impact whether you plea or not? Could it impact what discovery you seek? Could it impact whether you go to trial? Could it impact your appeal? And here they clearly withheld all the critical information that would have motivated him to take a different path. So they withheld information that could have been helpful to him. And that's the standard. Is there information I, as a prosecutor, am in possession of or can get access to that could be helpful to the defense?
And because if Jennifer is watching this, I won't mention anything more than that. The question was, I was talking to her about this. He pleaded guilty. He pleaded guilty based on the evidence that had been disclosed to him at the time. He pleaded guilty based on the understanding that they would not prosecute his son or not investigate his son. That was known to Flynn at the time he pleaded guilty, but not known to the general public as to how the FBI goes about it. That was subsequently released to the general public, I guess, to color or at least to enlighten our understanding. But he pleaded guilty based on the information at the time to save investigation of his son after 3 years of prosecution, promised no jail time, or a slap on the wrist in terms of punishment, but had already gotten fired and already gotten prosecuted, which was exactly what the FBI wanted as per their notes. Get in front of Sullivan. Sullivan starts talking things like treason. I might sentence you nonetheless. And then at that point gets a new law firm who obtains this information either that his former counsel had, but had not disclosed to him, or did not obtain from the FBI. I'm unsure as to which it is. And then gets these newly disclosed piece of evidence which show the malicious intent of the FBI in all their dealings with him from the very beginning. So if knowing that does not attenuate your understanding of him having pleaded guilty, that's a question of discretion or judgment and not a question of knowledge of the facts. Did his prior law firm know of the FBI notes? Did they have them in their possession but didn't get to them, or did they not have them?
They didn't request them and didn't have them.
Okay. So
the other aspect there is, of course, they had conflicts of interest, which made it such that he did not get adequate legal representation in that process. Yeah,
the conflict of interest, and that was another thing I was explaining to people who may not understand that, but they should if they've seen our previous vlogs, that Flynn was facing certain violations as relates to FARA, the Foreign Agency Registration Act.
Also insane. Only been 6 prosecutions on that in history. Never been a prosecution in the Logan Act in history. Major constitutional problems with it. He didn't even violate it if you even considered it something worthy of looking at for prosecution. Number one. Funny that Joe Biden would think of the Logan Act. There's a guy who's been violating every law known to man for decades. But put that aside for the moment. Joe Biden would know all the laws that govern potential corruption involving foreign officials. Let's put it that way. He may have been briefed on that in multiple contexts. But the other is that the FARA, the Foreign Agents Registration Act, also has constitutional problems. It's only been 6 prosecutions in history until these cases were brought. Tony Podesta, John Podesta's brother, was never brought up, even though he was far more culpable than Paul Manafort was. Paul Manafort was effectively working for him. So all of that was bogus. The Turkey-based prosecutions ended up being thrown out by the court. So in the Flynn related cases in Virginia said the evidence didn't support it at all. So it was all based on bogus threats, bad legal advice, withheld information to coerce a confession, and false confessions happen all the time. I can get you put like I said that great film, which has Gene Hackman and Morgan Freeman in Puerto Rico. Just watch that film to remind people why false confessions are the least reliable evidence, other than eyewitness testimony, that exists in our criminal justice process.
Yeah, false confession. I think people need to appreciate that. And I was explaining my learning curve from all of this, because I started off from the get-go as he pleaded guilty. He must be guilty. He got fired, and he got what he deserved. And only through this journey did fully understand. I mean, a lot of the information only became available in April 2020, so nobody knew this beforehand, and madness. It's absolute madness. Mike Brown says, so who or what holds Sullivan accountable for his unlawful, unethical actions? Wouldn't an attorney who did something like this face a disbarment?
Only a defense attorney. Prosecutors, they did a study a couple of years ago. 2,000 prosecutors who were found as part of a judicial record to have committed grievous, severe misconduct. Only 2 of them ever faced any ethical consequence. So the probability of facing a consequence of even prosecutors is very low. Judges, pretty much never. Only time a judge has to get caught taking a bribe and be politically disliked for anything to happen to them. And even then, they usually get impeached. Like I said, one of them is sitting in Congress right now and from the state of Florida. So, he got impeached. He committed bribery, and now he's a congressman. So that's what happens to judges. They only get hammered when they go against the powers that be, not when they go with the powers that be.
Okay, amazing. And I just pulled this. I put up Matthew Christ's press X if Yates and Biden Obama holder are corrupt. And now I'm looking at the chat, which is an interesting response. Okay, I think that does it for Flynn. That should clarify all of the lingering questions as to when he is officially a free man, if the Court of Appeal takes this up en banc, which we'll know by July 4th. And what a fitting day, incidentally, that is. So this can't get dragged out very easily to November unless the Court of Appeal takes it up en banc and says, now we got to set up a schedule.
Correct.
Okay. Checking out, and Robert, we'll say our goodbyes afterwards. See you guys later.